Wir haben, dürfte passen, wir sehen es vielleicht.
Ja, super. Ja. Also, aber guck mal, der Kameraausschnitt ist nicht gut, weil das Rednerpult ist genau abgesägt.
Aber warum ist das? Achso, aber weil das
die Kamera einfach verstellt.
Nein, weil das einfach anders angezeigt wird auf dem Bildschirm der Kamera.
Achso, ne, ja klar, weil die Box den ja einschneiden muss.
Ja.
Kann ja keinen Weitwinkel geben.
Dann zeig nochmal das Bild. Aber das ist auch ultra verzögert, ne?
Ja, natürlich hat das ein Delay.
Ja, aber so ist gut.
So ist gut? So können Sie stehen. Also, genau. Ja, Sie haben auch ein bisschen Bewegungsfreiheit, vor allem in Richtung Präsentation. Da haben wir so ein, also etwa bis zum ersten Drittel des Bildes können Sie sich auch ohne Probleme bewegen, genau. Das ist auch kein Problem. Der Präsenter war Leser.
Wir warten noch einen kleinen Augenblick, weil noch weitere Gäste waren. Faris
Übersichtlich. Sie müssten sich an das Rednerpult stellen. Warten Sie ganz kurz. Jetzt.
Darf ich?
Ja, Sie dürfen.
Herzlich willkommen. Welcome to everybody. I will speak in German with my introduction, but then we switch to English, which is of course the language of arbitration, so to speak. Aber ich denke, wir können eine kurze Einführung und eine Begrüßung auf Deutsch machen. Ich freue mich sehr herzlich, auch im Namen meiner Kollegen, Professor Hanschel, Professor Aleev, Marie-Claire von Bletz vom Max-Planck-Institut, dass Sie, die Studierenden, die Mitarbeiter, Interesse gefunden haben an dem heutigen Law After Lunch. Wir wollen hören einen Vortrag zur Deutschen Institution für Schiedsgerichtsbarkeit, German Arbitration Institute, von Korinna von Trotha, die ich sehr, sehr herzlich begrüße in unserer Runde. Es wird ein Vortrag sein, wenn ich es richtig verstehe, der von Frau von Trotha primär bestritten wird, and afterwards Faris Nasrallah will step in and, so to speak, at the end it will be a joint exercise, if I understand it correctly. Frau von Trotha leitet das Berliner Büro, oder das Büro dann eigentlich, weil es ja des Deutschen Instituts für Schiedsgerichtsbarkeit, eine Institution, die gleich vorgestellt werden wird, zu der ich an dieser Stelle also gar nichts sagen möchte. Ich möchte nur die Referentin kurz vorstellen. Die Leitung des Berliner Büros ist seit September 2015 in ihrer Zuständigkeit. Vorher war Frau von Trotha Case Managerin in Dubai, am Dubai International Arbitration Center, einem wichtigen Schwerpunkt internationaler Schiedsgerichtsbarkeit weltweit, so kann man, denke ich, sagen. Und so steht es jedenfalls hier in ihrer damaligen Tätigkeit, waren das bis zu 600 Fälle, die dort bearbeitet wurden von den Mitarbeiterinnen und Mitarbeitern. Vor Dubai, das war seit 2009, zuvor war Frau von Trotha Deputy Counsel im Sekretariat des Schiedsgerichtshofes der Internationalen Handelskammer, der ICC in Paris. Sie hat studiert Rechtswissenschaften in Heidelberg, in Singapur und in Durham und das erste Staatsexamen in Freiburg und das zweite dann in Düsseldorf abgelegt. Herzlich willkommen bei uns. Wir freuen uns außerordentlich. Das internationale Wirtschaftsrecht ist bekanntlich ein Forschungsschwerpunkt der juristischen Fakultät hier insgesamt und in diesem Zusammenhang der Schiedsgerichtsbarkeit, sicherlich auch durch die Unterstützung, die wir durch Herrn Alev vor einiger Zeit bekommen haben, meine eigenen Aktivitäten, ist gerade die internationale Schiedsgerichtsbarkeit ein sehr spannender Gesichtspunkt unserer Forschungsarbeit, den wir aber auch immer wieder, und dazu dient auch die heutige Veranstaltung, mit praktischen Gesichtspunkten kombinieren. Schiedsgerichtsbarkeit kann man eigentlich nicht nur wissenschaftlich machen, sondern der Praxisblick, die Praxiserfahrung sind ganz wesentlich und wichtig. Insofern ist es eine tolle Bereicherung, auch für uns sozusagen, die wir natürlich primär bis aus akademischen Perspektive betrachten. Herzlichen Dank nochmal, dass Sie aus Berlin zu uns gekommen sind. Ich freue mich auch, dass wir so sozusagen den Kontakt einmal mehr auffrischen können und Sie im Ergebnis dann auch die schöne Stadt Halle und die Martin-Luther-Universität in guter Erinnerung behalten. So viel dazu. Wir steigen unmittelbar in den Vortrag ein. Bitte.
Hello, everybody. I'm very happy to be here today. I have to admit that I haven't been to Halle before, although you might have heard about the place Halle-Trotha, which is not far from here. And I think my family was first documented in 1291. So actually I'm coming home. So that's really a great pleasure to be here. It's also interesting to hear that most of you are looking into arbitration from an academic perspective. I have to say, personally, when I went to university, I didn't hear anything about arbitration. I didn't know about its existence. And I learned everything by working in arbitration. So I learned everything at the ICC, in Paris, in Dubai, and now at the DIS. So there might be lots of things for you to share with me because I have almost only a practical view on things and not so much an academic view. So it might be really interesting to have an exchange on certain matters. And I also invite you to raise your hand or just speak out loudly when you have any questions during my presentation, because later on we will anyways have a conversation, so why not start this also earlier? So I invite you to do this as early as you wish. So let's start. I just want to show you what we are going to talk about today. We have divided this hour that we have together in 3 parts. The first one is for me to introduce to you the DIS, our institute, who we are, and the bodies that we have and how we are kind of composed. In the second part, I would like to present to you the services that we render, the general functions, some statistics so that you know the dimensions of the work that we do, and also a very quick introduction to the new DIS rules that entered into force in March 2018, so they are roughly more than a year old. And I brought for everyone a copy, so if you don't have a copy yet, there are some more over here or placed on the table. And then in the third part, we will have a little conversation, Faris and I, and talk about cross-cultural aspects of arbitration, although I'm trying also to fit this topic already into my presentation, so we might have some things to go back to while we talk. So let's first look into who we actually are. The DIS is, if I may say so, the leading institution in Germany for national and international arbitration. We are organized as a private non-profit organization. We have association. So as associations are, we have members. We have roughly 1,500 members within Germany and also abroad. And the main secretariat is located in Bonn. Some of you still may locate us in Cologne, but we have recently moved to Bonn, Bad Godesberg. And then we have an office since a couple of years, since 2011 in Berlin, and that's where I'm located. But the day-to-day management of cases is done in both locations. In Berlin we do mainly sports arbitration, and the commercial arbitration is done in the Bonn office. And you may see us around traveling a bit or hear from us from different conferences and activities, not only regarding the case management, but we as an institution also have to do a lot of promotional work. And you may wonder how many people are actually working in the DIS, and we are only 14. So we often get proposals, why aren't you going to this and that, and why don't you open an office in South America, and that would be so interesting. And then we have to say, well, we are just 14 people, so our outreach needs to be very focused, and we can't be everywhere. How are we organized? We have an advisory board, and the chairman is Dr. Rolf Trittmann. He's actually a partner with Freshfields in Frankfurt. We have a board of directors. He is maybe known to you because he is a professor and a part of the US-Iran Claims Tribunal, and he was a professor in Heidelberg. So he's not known to all practitioners actually in the arbitration world, but for you, you might have heard about Professor Kronke before. Then we have our secretariat, as I said, in Bonn and in Berlin. Our Secretary General is Francesca Mazza, and the Vice Secretary General Victor von Essen. And then we have two bodies. One of them is relatively new. I will tell you about it. That's the Arbitration Council. The chairman is Professor Dr. Klaus Sachs. He's partner with CMS in Munich. And then we have the appointing committee. That is a committee that has been existing for quite a while, and I will tell you later what their functions are. Interestingly, regarding these bodies, I wanted to put some intercultural matters into perspective here. The Arbitration Council comprises of 15 members, and 16 of them are actually foreigners. They are non-German members of the Arbitration Council, from Italy, from Greece, from the US, so it's quite a bunch of international people. The appointing committee, we have 3 members, and one of them is a non-German, and 2 of them are Germans, but they are practicing abroad, so they are located in Paris and in Brussels. As these 2 committees have been created, or this one has been, the members have been reappointed relatively recently, and this one has been newly created in the framework of the new DIS rules, we had the chance of putting these international people on those bodies. So this is quite a recent effort to actually make DIS also from the bodies a more internationally composed institution. Next, what we are actually doing, what are our services? Well, if you look into the rules, paragraph 2, subparagraph 1 says, with respect to any arbitration, 2.1, it's here. The DIS administers arbitration under the rules and provides support to the parties and the arbitral tribunal for the efficient conduct of the arbitration. It does not resolve disputes itself. This is basically the short version of what we do, mainly. But it might remain a bit of an abstract description of what we do, and this is the list that I've given to you is the more is the wider perspective on this very short definition of our task. So overall, we assure the smooth running. Over today, we will focus on arbitration. We receive and notify a lot of correspondence that is going between the parties, the tribunal, and us. We have to analyze procedural matters. We always focus on the proper application of our rules. And we need to prepare also the decisions that are taken by the appointing committee and also by the arbitration council. So this is our legal and analytical input that we give to those bodies and to the work. We have to handle the financial aspect of the case. So as you can imagine, parties have to pay for the services, to pay for the use of the DIS, and they obviously also have to pay the arbitrators once they have done their job. So we actually ask for advances from the parties, and we have to always check whether we have enough money in the kitty to be able to pay the arbitrators when they've done their job. We also support the parties in the constitution of the tribunal. Experienced counsel and parties know how to choose arbitrators, and they know where to look for them and how to get them into the case. But a lot of people or parties that use us, and we have also new counsel, they do an arbitration for the first time, so we have to support them in this process. And sometimes it's just not possible for parties to actually find a suitable arbitrator, or that they don't want to nominate an arbitrator. And in all these circumstances, we would support the parties in constituting the tribunal to be actually able to run the arbitration. Then we also have a limited quality control, mainly over the final award, which is the most important document that is handed to the parties at the end of the arbitration. I will talk about this a little bit later as well, because it's part of the description of the new DIS rules and what has changed in this respect. We also always try to speed up the arbitration process, so parties can be sometimes quite difficult, objecting against each other's proposals, how to run the arbitration, and we always try to solve those little mini disputes within the bigger picture as quickly as possible. And then we are also there for the parties to be consulted on the application of our rules. Obviously, we always need to stay neutral. We cannot be a counsel for one side and tell them what would be the best thing for them to do for their position. So we need to make sure that we remain neutral, but if there are general questions regarding the application, how certain procedural aspects work, we are happy to explain, either before an arbitration even starts or during the process. All this, to how many cases does this apply? As Professor Titje kindly mentioned before, at DIA there were times where we had 600 cases pending at a moment. DIS actually has a little less. We have 250 cases approximately running at the same time. And here you can see how our the registration of new cases has evolved over the years. The last edition of the DIS rules was from 1989, so we have started the table from there. And last year, in 2018, we had 162. So the highest number was in 2016, and now we have a slight backward trend. Also, what is quite interesting to know usually is the amount in dispute of cases filed, and as you can see here below, some cases are really tiny, 1,220 euros. Sometimes as an administrator you think like, should I just write a check and we get rid of the case? Because this is really not efficient, of course, to run an arbitration for such an amount. But as you can see on the other side, we have, last year at least, we had a 90 million case, and sometimes they're even bigger. So what are the features of those cases? Some more statistics. What is always interesting for people to know how many domestic and foreign cases, international cases we run. So we have a relationship from 40 to 60 approximately. So 40 international cases to 60 domestic cases. This correlates more or less also with the language of the cases. So last year we had 30% of cases run in English and 70 in German. We have come outside Germany, we have companies coming from quite a range of countries. So last year in 2018 we had parties from China, Mexico, Russia, Singapore, Turkey and the US. And one aspect is always the complexity of cases. Obviously it's more interesting to have cases where several parties are involved, where several contracts have been entered into by the parties, so this makes usually the amount in dispute higher, the parties involved more sophisticated, so this is something you usually look for. So how many multi-party cases do you actually have? And this correlates also a little bit with the English and the German and the foreign influence or foreign use of DIS services. So we have roughly 30% of cases where we have more than one party on one side. Yeah, let's now look into the DIS arbitration rules, the new ones. They entered into force on 1st March 2018, so as I said, they are we just celebrated the birthday of the new rules during the spring conference that we held in Bonn, where this was also a topic. We wanted to see how they're doing and how they have been adopted by the arbitration community in Germany. Interesting, in comparison to the old version of the DIS rules, now we have an official English and German version. So we have two official versions. Before we had only the German version as an official version. We had actually a drafting committee that was, their main task was to produce this official English version. It's not a translation. You will see that there are some provisions, they don't sound like a translation. They really sound as a proper self-made rule. And then obviously we are also working on some translations. There are a lot of people interested in having the rules translated into Italian, Spanish, Polish, Russian, Korean. This is all underway, but so far we have not yet uploaded any of the translations. Some of them are in the final stages. What are the features of the new rules? Well, this could be a lecture on its own. We are going around in the world and presenting these new rules, and there are lots of presentations and workshops, but in a nutshell, I want to point out three aspects for you. The first one is modernization of the arbitration rules. Well, as you can see, the last version was from 1998, so 20 years have gone by, and there was a lot to be polished after 20 years. The leitmotif, or the main goal under the modernization aspect of the rules was, if it ain't broke, don't fix it. So we didn't kind of follow every trend that you can observe around the world with regard for emergency arbitrator, mandatory expedited proceedings, for example. There are lots of other institutions that have chosen these new mechanisms, but we decided not to introduce all of them into the new rules because we were quite happy with the way the rules were drafted before, and we just changed what we really thought was necessary to change. There are a few changes. For example, we introduced a light scrutiny process. I will talk about this a little bit later. We introduced new provisions on complex disputes, the multi-party and the multi-contract provisions. And there is also a very important other aspect which I'm going to talk about now. For example, this balance between making the rules ready for international and domestic use. The older version of the rules was considered to be rather for domestic use. There were quite strict provisions on settlement of disputes, for example, and this settlement of disputes, we might enter into a conversation about this also later. You will see that's a very much civil law approach, and not even only a civil law approach. It's a couple of countries in around Germany and around Germany, Switzerland and Austria, that have a similar approach to settlements. But for example, Sweden, as a civil law country, isn't used to the way we do settlements in Germany. So we tried to reformulate our settlement provision in a way that international users are not offended or irritated, or they think, what the hell are the Germans doing here with their settlement approach? So we wanted to make overall the rules more acceptable also for international use. Obviously, in this vein, there is also the fact that we have now two official versions, the English version, that makes our rules easier to apply also for international users. Then we have quite an interesting provision right in the beginning and in Annex 6, which is the conflict management or the conflict manager. That is a rule. We had the conflict management rules before as a separate document, but they were never picked up. We didn't have a single case under the conflict management rules. So we thought we might need to introduce something in the new arbitration rules to make them more popular. The conflict manager is a person who helps the parties to find the right dispute resolution mechanism before you actually enter into arbitration proceedings or any other kind of any other alternative dispute resolution mechanism. So you simply have a dispute and you think, well, what would be the best mechanism to solve this dispute? And you approach the conflict manager and have the dispute analyzed by someone who can then recommend the right mechanism for you. And this is something which is now a little bit stronger emphasis even in the arbitration rules, that at any time during the arbitration you can actually go back and reconsider whether entering into arbitration was a good thing, and you could change the mechanism. We know that this might also not be something that is used regularly. Once you draft your statement of claim for an arbitration, it's maybe slightly unlikely to go back and say, okay, let's rethink about the whole arbitration from scratch. But at least I think it puts the conflict manager in a more important and visible role or position. And so we hope we will have more case and conflict manager proceedings run. And then you can have a look in Article 27. This is anyways one of the core parts of the new BIS rules. It's about efficient case management. And one provision within, it's in 27.4, we oblige the tribunal to discuss with the parties alternative dispute resolution mechanisms in the case management conference. So again, in the case management conference, we open up the box and say, well, if you are not happy with arbitration and we could maybe mediate this case instead, let's at least think about it. And if you consider that this is not the right approach, we go back to arbitration. So in the vein of making it, on the one hand, more international, we also tried in a couple of provisions to make the arbitration process that we administer more flexible and open to other ways of dispute resolution. Then the next point would be more transparency and integrity of the arbitration procedure. This is quite an interesting approach, I think, for the rules. Here comes into play the Arbitration Council that I talked about before. This is a newly created body that did not exist before, and they have now certain powers within the process that were not under the DIS administration. So, for example, we have introduced the possibility of the institution to remove arbitrators. And this is the Arbitration Council who would make this decision. But also parties can apply for the removal of an arbitrator, and this would also be decided by the DIS Arbitration Council. But this removal of arbitrators from the initiative of the institution, that was not part of our previous rules, and that's obviously very problematic, because you see a couple of arbitrators that do not perform the way they should perform. The parties may be somehow aware of this, but for them it doesn't make sense to challenge the arbitrator or to apply for this removal. So it has to come from the institution, and if you can't do it, then you end up in a very difficult situation. So we are very happy of having this power now to remove arbitrators. And then this DIS Council also has an interesting power with regard to fees. For example, they can decide if an arbitration tribunal doesn't render the award in time, and the time is now fixed by roughly 3 months, they can actually reduce the fees of arbitrators if they consider that they, with no reason, have rendered the award too late. That is quite a powerful tool, actually. What they can also do is they can review the determination of the value of the case that is determined by the tribunal. And as you probably quickly understand, the tribunal is more or less interested in having a high amount in dispute, because that will reflect on their fees. The higher the amount of dispute, the higher the fees of the tribunal. So you often have parties and arbitrators or tribunals that quarrel about the value of the dispute. And there are some cases where it's not a clear-cut decision. And so under our system now, the new rules, the parties would have the possibility of requesting the DIS Council to re-examine the determination of the amount in dispute of the tribunal. So this is also quite powerful and useful, I think. And then there's also the possibility, the adverse situation, that arbitrators actually do a very good job in very complex cases, where you would say the fees which apply under the usual scales are too low. So there's also the possibility of the tribunal to ask for more fees, to increase the fees. And this is also a decision that is taken by the DIS Council. Well, this is just a little insight into these little things that make a very big difference in arbitration proceedings when you have a toolkit to shape the arbitration process. And you might find more if you read the rules carefully, but these are maybe the most important ones. And at last we have obviously acceleration of proceedings, efficiency and quality management. This is something the whole arbitration world is constantly talking about. How can you make arbitration more efficient? How can you make it less costly? Obviously, that is this triangle that is difficult to have it cheap, fast, and to a very high quality. That is almost impossible. but we all try to shape the process to get as close as possible to this ideal. And what we have done, we have shortened a couple of time limits. As they were before under the rules, parties have to stick to quite tough time limits in order to, especially at the beginning of the case when it comes to filing the answer, nominating arbitrators, and so forth. In terms of efficiency, I also already pointed out paragraph 27, article 27 of the rules, is a very long paragraph that describes in detail what the arbitral tribunal and the parties have to do in order to make arbitration more efficient. So they actually have a very strict checklist that they have to go through, and that's mandatory during the case management conference to discuss these points, so that no one at the end of the case can say, oh, why didn't we discuss this earlier, or why didn't we think about this or that procedural aspect. Then the quality management is also a very important new step. This is something we have done in the past, but it was never written in the rules, how we actually scrutinize awards. If you have ever dealt with other institutions, the ICC, for example, has a very strict scrutiny process, and the awards are approved by the ICC court, and they can be approved as is, but that's, I think, only 1% of the arbitral awards that actually pass without any comments. And then the court can issue awards that are approved subject to, and then comes a very long list of things that the arbitrators still have to do before they can actually, the institution would actually notify the award to the parties. In our case, we tried a compromise between not reviewing at all and this very sophisticated process of the ICC. The ICC process is, of course, costly, and it involves a lot of people, so that is a very high administrative standard that you need to have in order to be able to do this kind of scrutiny. We can't do this at the DIS as it is now for the time being. And so we do a middle thing. We look at the awards, and we look out especially for formal aspects of the arbitration in order to draw them to the attention if we have the impression by reading the award that there might be enforcement problems if they are not adhered to certain standards. So this is what we do. We can also draw the attention to material matters, substantive matters, but obviously we need to be a bit more cautious in this respect. So we do read the awards, we do call arbitrators or send them an email and tell them, look, this is what we would do, but it's not that if the arbitrators would say, I don't do this, or there are certain reasons why I stick to what I do, well, then they stick to what they do and they send it off. Here comes also into play something we might discuss a little bit more later. The standard of legal education in Germany is very high. And you will see, if you give somebody a call who has been doing arbitration for 25 years successfully, and you'd call him or her and tell them to change something in the award, they might be actually quite annoyed. Yeah. And so we are careful with this, and the ICC is operating worldwide, and the standards of awards that they receive are very diverse. So it's from very basic to super sophisticated, and we observe in the German market, or the awards that we usually get, that they are all okay, at least okay, and we don't need to have such a strong influence as you have to have when you operate worldwide. So that was also the background why we decided for this kind of compromise in the scrutiny. So I think that's it from my side right now. Yeah. We have a little aspect left regarding the appointment of arbitrators, but maybe I don't know how you feel about it.
Yeah.
Would you like to?
I just wanted to make an additional point to supplement the very useful background that you just heard on these procedural rules. And that's really to give an explanation as to where the rules sit in a kind of hierarchy of laws. So the procedural decisions that an institution like the DIS would be required to make on appointment of arbitrators, on defining time limits for accepting certain documents, for taking all manner of procedural decisions at the outset of the proceedings. They often see the interface of various different legal provisions, laws, rules, practitioner guidelines, and I think where it's important to keep in mind that where these rules sit is almost what Korinna and I discussed previously as being something we call soft law. But again, this is really to take it to the more theoretical level now. If you define what these are as soft law, then you must answer the question of what is hard law. And then you're in all kinds of different debates which are very interesting and I think are worthy of discussion. But to give a very brief example of how this might relate in practice and how you might have soft law, hard law, and then what I suggest is kind of the normative behaviour of arbitration practice sitting somewhere in between. If you look, for example, I would say at, let's take, if we take Article 7.7 and equally 7.6, if you look at the wording at the end, for example, where it says the DIS may terminate the arbitration, so if it decides that the respondent has not fulfilled their duties or filed the counterclaim in time, or a particular document in time, the institution has within its gift, according to the rules, the ability to terminate the arbitration. That's a very serious position to be in, and it has a number of consequences. Now, before making that decision, you'll see in the language it says it may. Before taking that decision, the DIS will have to consult the law governing the merits of the arbitration, the procedural law of the arbitration, and also some of the norms and practices of the parties involved, the jurisdictions in which they exist and operate, the background of the arbitrators, if there is already a number of suggestions or nominations made. And so you can see, for example, how in a very particular or focused issue such as this, the DIS has really kind of almost like a hierarchy of different norms that it has to adjudicate on. From another perspective, I can say as a practitioner, so this is now in my experience in practice, another reason why I would encourage you to consider these rules not just as rules for the DIS but also as a form of soft law is because I could easily see myself relying on these rules in my pleadings. And I think I'm sure, well, maybe Korinna would have seen this in her practice, but often as counsel, when you're making arguments about certain procedural points, you may well draw on the rules of a number of other institutions. So you may well wish to say to the tribunal, respectfully, I invite the tribunal to dismiss this arbitration on X grounds. As you will see, it may not be supported by the rules of the current institution where we're operating, but if you look at the ICC, the DIS, the LCIA, and you can cite all of these different soft laws, it can become quite a compelling point. So what I wanted to add to your very useful introduction was that the rules are also a form of soft law. They can also be a form of soft law in international arbitration.
I've actually seen this kind of argument, but it was funny because I was in charge in Dubai for the case management, and we introduced a couple of stricter ways of handling parties and arbitrators. It was a bit like an off-roading there in Dubai before I landed, and it was a new institution, And so they sometimes, very sophisticated law firms that operate all over the globe, they started, yeah, but at the ICC they have this and this process and they do it this and that way. And then I said, hold on, no. So they tried to argue with the practices they might find somewhere else. I mean, it's good if the practice you are referring to is true and is actually a practice. They tried their luck in saying something different. Obviously, as a case manager, you would then not tell them, well, that's wrong what you're saying about the ICT, but you would just do what you suppose, what you have to do under the current rules. But it's a practice that you would see reference to the practice of other institutions, and then you can consider it at least and think about it, whether it makes sense within your own framework to deal with it in a different way. Or
from a purely theoretical, dogmatic perspective, however, and in light of what you just said, I would be hesitant to talk about soft law, because first of all, this is law once the parties adopted according to the arbitration clause. It's not soft law, it's law.
This is law.
According to the, based on the consent of the parties, of course. First, secondly, what you just discussed, or my question is, that's known, that's what we do under the heading of comparative law, as a tool, as a means of interpreting the law. That's what we do in any kind, whether it's constitutional law, civil law, public international law, investment law, whatsoever. We use comparative law analysis as a tool of interpreting within the framework of the wording, of course, of the respective provision, certain agreements. So I would rather put it in that category, so to speak. It's part of the let's say, legal environment of arbitration globally, and in this regard, as far as possible, you use comparative law analysis in order to use it where it fits. But that's not soft law.
Yeah, no, this is a way of arguing your case.
Yeah,
and
that's the idea. Yeah,
if there is another practice somewhere around the world that is in your favor, you try.
Absolutely.
Yeah, sure. Yeah. No, I fully agree. This is not. We do have a lot of soft law within the arbitration world. I mean, we have the IBA guidelines.
Yeah, we have the
have
guidelines.
the new Prague rules. These are all. And the guidelines of the IBA go in different directions. There are guidelines on the independence of arbitrators, but also for the taking of evidence. So they have produced a couple of sets of rules that apply or may apply to an arbitration. Yeah. The most interesting one is the Prague, the recent ones.
I have two questions. First of all, could you illustrate a bit further the cross-cultural aspects of arbitration in terms of access, power, etc., and how it matters, in terms of cultural background? Some of the things that Faris, I think you were pointing out when we were at the MPI. That's the first question. The second is more maybe geared towards Korinna von Trotha. I see that in your introduction you write that one specific feature about the DIS arbitration group is the promotion of amicable settlements, and that this is a European element, a continental and German element that distinguishes it from others. I would really like to know further whether this is a purely technical remark, that you find this in continental legal orders more often than elsewhere, or whether it is also something that might appeal to culture, whether you think, or the DIS thinks, that in Europe we simply do this differently and the DIS reflects it to a certain extent. Just to kind of elucidate and illustrate a bit further on those cultural aspects.
Well, with regard to the settlement, I think we do observe in practice this practice of settlements, and arbitrators are used to offer the parties their views quite early on in the proceedings, so they may agree on a settlement, but it becomes a problem. Or if you, for example, if you have a German chairman or a Swiss chairman who's used to do that, but you might have one party that is not used to this practice, then that party might be a little bit shocked and would consider challenging including this arbitrator later on. So I think there is no a balance between what's written in the rules and what is in practice, because there are several, especially Article 26, but you find it also in other provisions that deal with the settlement. So if you agree to DIS arbitration rules, you need to be aware that there is a tradition or practice of settlement that goes through the whole arbitration procedure. But you can opt out. You can say as a party from the very beginning, look, I love your DIS rules and the process, but the settlement thing is something I can't handle. I can't handle with my party, I can't handle with my co-counsel, whoever is a stakeholder in the process. And you can opt out and say this very clearly in the very beginning, let's do everything except trying to settle this case. I need the final award in the end to take it home. And so I think there is quite a balance now between the theory and the practice.
I think just to add to that, one of the issues that maybe I covered previously at Max Planck was this process of the judicialization of arbitration. It's not so much a clean or unimpeded road ahead whereby arbitration is on course to just become another type of court proceeding, but there is definitely, for example, in this particular aspect of the DIS rules, something that reflects the pre-action protocols of established court proceedings, definitely in the UK, but also, as I understand, in Germany and other continental systems. So there's something to be said about that. And that correlates with also the rules towards transparency and efficiency, which I think are now pervasive across most of the established arbitral institutions. To come to the point about the cross-cultural aspects, really probably one of the most significant interfaces for this cross-cultural interaction is between civil and common law practice in international arbitration. If you take, for example, aspects of the proceedings like document production, there are vastly different views between the parties sometimes and counsel on what document production is there to serve, what its purpose is, how it can be used. In the civil law tradition, not to oversimplify the position, but the position broadly is that I will only use or admit whatever I seek to rely on. In the common law tradition, there's a more broad, I would say, kind of revelatory approach to discovering new information and asking for new information to be produced. In arbitration, there's kind of a hybrid system which has been established, which sometimes actually reproduces itself as a case within a case. It's a document production phase inspired by common law practice. It's often called, what practitioners call it, they call it a Redfern schedule. It's a document production sheet. So you have a landscape style document with 5 or 6 different columns on it, and then you have the name of the document, the date of the document, the reason why you believe it should be provided or produced, and then a citation of the particular rule that you rely on, maybe in the IBA rules of evidence or in other rules of evidence. Again, this is where we talk about the hierarchy of norms. And so you have a completely hybrid interface of these different legal systems and cultural ideas about law in that one process. I mean, to give you a particular example about Dubai, I often had the problem culturally in Dubai where clients wouldn't want to give you information at all, even to prove their own case. A lot of local companies, they had it as a point of principle that it was their secrets. Why would I give you my secrets? You have to earn my trust first. So I recall in one case, I had to build a relationship with 3 or 4 other people in my law firm for an entire year with a client in order for him to trust me to give me the information, access to a room, as if I was going to find it was going to be Aladdin's cave. And then we went in and had fairly ordinary construction documents in there. But these psychological, cultural processes, you find them. They cut right in between all of these different laws and procedural rules, merits laws, and then you're in a position where you need to look at the norms and you need to understand the basis for these approaches, or you end up in clashes. If you just simply have time limits and certain rules that apply, and then the arbitration gets kicked out, and then, it doesn't work that way.
Interestingly, I mean, the